Mary Morgan, 1988, is actually Mary Moss. I was 17 then. I was the London Development Officer for the National Association of Young People in Care. Just waiting for the tape to rewind, and then it's really long and boring. But it's interesting if you have an interest in Radio 4 type of programs about children's rights, and then, now it's much worse. All these unregulated placements. It's like prostitution. It's fodder. It's just like Afghanistan, and selling kidneys, and it's rubbish. I don't even watch that bloody war. Propaganda, my friends. I've got an inquest. I was looking for a lawyer today. I've got an inquest coming up on them. And, I love the money. Totally illegal. Right, here we go. Right, I'm going to give this to you now, so sorry about that.
With Sue McGregor, nodding in the direction of politics today, Sue.
Well, David, yes. Will there or won't there be a general election in June? All the political parties say that they're ready for the off. Well, they would, wouldn't they? And the manifestos are being poured over by the pundits, even though they're probably only in draft form so far. This time, most of the parties will have something special to say to women. That's why we're covering that today. Each in their own way will want to woo the greater part of the electorate, whether they feel that so-called women's issues are a separate item on the agenda or should be woven into all important questions of social or industrial policy. We'll be talking to representatives of all the main parties about what will be in those leaflets. We also go gardening with Daphne Ledward, who admits that all gardeners are basically idiots, in our climate anyway, but who knows how to make the digging and the sowing and the clipping fun and rewarding. And you can meet expert and award-winning cook Frances Bissell. Join us for that and lots more ingredients. Woman's Hour, 2 minutes past 2.
BBC News at midday. More than 80 Tamil separatists have been killed and about the same number wounded in a series of air raids by government planes in the north of Sri Lanka. Among the targets were said to be bases used by the group blamed for yesterday's bomb explosion in Colombo, which killed more than 100 people. Earlier, at a prison in Colombo, prison officers used batons and fired shots to prevent a massacre of Tamil prisoners by Sinhalese inmates. It's reported from Cyprus that 2 Arab men have been arrested in connection with the ambush on Monday, in which a British serviceman and a 16-year-old girl were shot and wounded. The men are expected to appear in court in Limassol later today. The leader of the Democratic Unionist Party, the Reverend Ian Paisley, and the MP for East Belfast, Mr Peter Robinson, have been detained.
To last. Today, children's rights.
I reckon children should have to say in what they do, because it's their lives. What happens to them, they should know. We should be asked because, like everybody else, we're human. We ain't different. It's not that we've got halos around to it or anything. It's just that we should be asked.
And Michael should know, at 15 he's an expert, kept in local authority care since the age of 4. He's learned the hard way that the few rights children do have can be easily abused by others.
Chaz.
Today, with the help of Christina Lyons, Professor of Law at Keele University, we're examining those rights, which are largely the same throughout the United Kingdom. But to start at the beginning, well, you might even say before the beginning, Christina, does the unborn child have rights?
In fact, in the Liverpool case in 1978, the President of the Family Division said that a fetus in English law has no absolute right to life. But it's become clear that over the years, English law has recognised a patchwork of rights. In the Liverpool case, the father was asserting that he should have the right on behalf of the unborn child to prevent his wife having a legal abortion. The child at that stage was well under the 28-week legal abortion limit, and in fact he was unsuccessful in his attempt. In the recent Oxford students case, of course, the issue there raised was a rather different one, because the father in that case was arguing that the child was capable of being born alive, And in that case, the Court of Appeal, subsequently confirmed by the House of Lords, decided that a child aged 18 to 21 weeks was not a child capable of being born alive.
So the distinction in the law now seems to be whether the fetus can be kept alive once it's born.
That's right, but still allowing for legal abortions up to 28 weeks.
Then there was another recent case which seemed to comment on ill treatment before the birth.
That's right, the Berkshire County Council case where the mother had been taking drugs throughout the pregnancy, even though there had been attempts to dissuade her from so doing, and where the child was removed when it was born under a place of safety order, and then subsequently care proceedings were gone through. In that situation, the House of Lords ruled that in that situation you could look to the whole continuum of events leading to the removal of the child, and that could include the period before the child's birth.
So what sort of things might a mother now do before the birth which could affect the child's rights and her right to keep the child?
Well, one can argue now that she has a duty to take care of the unborn child in the womb, and that could extend, indeed, the House of Lords referred to the possibility of alcohol abuse, perhaps even smoking. That would clearly be taking it to extremes, but we have got the situation where, certainly as far as the taking of drugs is concerned, there could be grounds for suggesting that local authorities might legitimately remove children. But it has to be stressed that most local authorities have taken great steps to say that this is by no means automatic, just because the mother is taking the drugs.
So right from the outset, children have rights. There's the right to know who you are. We are very much the product of our parents and our parents' parents. Access to information about them is becoming increasingly important as the number of adopted children, single-parent families, AID children, and children of surrogate mothers increases. The need to know your natural parents seems to be very strong. As a baby, Jane, along with her twin brother, was given up by her unmarried mother and adopted.
It's just an enormous part of your life is missing. I was brought up in a lovely family. I had super parents. There's just something missing. There is a woman in the world who is your mother, your natural mother. She gave birth to you. And just wanted to know who I really was.
When she felt her adoptive parents would no longer be offended, Jane set about trying to find her natural mother. She'd been told the adoption was arranged by Westminster City Council, but before they'd let her see the file, a social worker discussed the implications with her. Did she realise that she might not get on with her mother? Did she appreciate that her real mother may not want to meet her, may well have a whole new family who didn't know about her? Reassured that Jane had thought it through, the social worker produced her adoption file, a thrilling moment itself.
Fantastic. Just lovely, because there was a letter written by my mother, my birth mother, a very, very sad letter, very, very sad letter, writing to the Adoption Association, asking how her babies were and were they being properly looked after, and that she simply hadn't wanted to give us up for adoption, and how broken-hearted she was. And to sit and see my mother's handwriting, this letter, was a very emotional experience.
A long search through birth, marriage certificates and help from NORCAP, the National Organisation for Counselling Adoptees and Their Parents, finally revealed that her mother married an American serviceman. She'd been told it was unwise and unfair to contact her mother out of the blue, so without revealing who she was, she wrote to the US services asking for details of where they now lived. But she only received a reply that her letter had been passed on to another department. It could have been a dead end. But then, one evening, months later, out of the blue, a woman rang her.
She said, "I'm phoning from America. You won't know who I am, but you were trying to contact my husband." Well, I knew in that split second, absolutely bang, that I was talking to my birth mother. I mean, just instantly, it was her. I just think I spent the next few minutes apologising, saying, "Well, I'm terribly sorry. We're just trying to make contact with you. Would it be possible to have your address? I'd like to write to you." Then she eventually said her husband had died. So I said, "I'm so sorry." But she said, "Well, why did you want him? What do you do?" You know, I was getting absolutely panic-stricken. And my brain was saying, "You mustn't say who you are. You cannot do this to this lady over the telephone. Just announce that you're her daughter. You can't do it to her. But if you don't do it, what's going to happen? She's going to go." So finally, because she started getting just a little irritable, quite rightly at the other end of the phone, you know, a strange woman in England who wasn't divulging who she was or why she wanted her husband. And I think her mind was racing in other directions. What her husband might have, you know, why I would want to contact him. And finally, I mean, I just in desperation said, are you? And I quoted her whole name to her, everything, all her full name to her. And she went very, very quiet. And then she just said, yes.
Yes.
And I just said, have you got any idea who I am?
I've just realised.
And she said, I've just realised.
Jane has still not met her real mother yet, although she hopes to very soon. They're now regularly in touch, though, by telephone. Christina, Lyons, what are the rights of adopted children to know who their parents are?
Well, in England and Wales, since 1976, children who have been adopted have a right to make an application to the Registrar General to be given information relating to their birth parents. In that situation, they are also told that they have an opportunity to have counselling. This is obligatory for those adopted, in fact, before the 26th of November 1976, but for those children adopted after, it will be optional. This right has actually existed in Scotland for children aged 17 and over since 1930, when adoption was first introduced there.
What about illegitimate children who may not even have details of the father on their birth certificate?
Then the only way they can find out is literally by asking the mother who their father was. There's no other way of finding out.
And children of surrogate mothers, again, is there any right at the moment for them to be told who their surrogate mother was?
No, except insofar as that should appear, of course, on the original birth certificate. There's no way of amending that. So again, if they are adopted by the father and his wife, then they will, in fact, at 18, again, be able to discover, if they know they're adopted, who their surrogate mother was.
And then there are the children of artificial insemination. That's a completely separate problem. Artificial insemination by a donor is increasingly the choice of women whose husbands are infertile and single women who don't want a relationship with the man but do want a baby. Claire is a case in point. She searched around for a man who'd provide the sperm.
One of them turned out not to be fertile. And the other one, who I didn't know at all, he was a friend of a friend, provided the sperm, and I became pregnant immediately. I'm going to tell him that he was conceived by artificial insemination, and why, which is that I very much wanted a child, and I didn't want to make a relationship with a man just to have a child. And I know his father. I'm going to tell him who his father is, and that the father and I discussed quite carefully the father's involvement with the child and decided that the baby could meet him if he liked from when he was about 5, but that he doesn't want to be involved as the father, and I certainly don't want him to be involved as the father.
But the National Association for the Childless is against letting AID children know the father's identity. The association's chairman is Peter Hub.
Overwhelmingly, the members of the association are against the child having a right to know, because they believe that the nurturing of the child requires, in its best interest, for it to be regarded solely as the child of those parents. You have to experience what it's like to feel that you're part of a minority, and a rather mocked minority, as many adoptive children have felt when you're young, to realise that you don't want to create artificials, as they're often called in America, artificials, with the same derogatory context as bastards.
However, an Australian survey of donors quoted to us by Dr. Alexina McQuinney from the British Association of Adoption and Fostering said 50% of donors there were happy for their children to have a pen picture of their characteristics, and quite a large percentage were prepared to meet the children. I put it to Dr. McQuinney that this could mean them meeting thousands of children.
But the reality is that the children will want to know. I mean, I think we've got to get our priorities right. We are not really considering at the moment the children's rights and needs. We're very concerned about parents who desperately want to have babies, and I have enormous sympathy with couples who can't have children and want them. But we can't completely overlook in our provision for this what we're actually doing. We're creating children who then we are giving no rights to.
According to Dr. McQuinney, there are important practical considerations why Parliament should let the children know.
Children are furious with them because they say, you have created brothers and sisters out there in the community whom we might marry.
Christina, what right do AID children have at the moment to know their natural father's name?
They don't have any rights at the moment to know their natural father's name unless and until one of the parents tells them who the natural father is. Where AID is performed under clinical conditions, then there is no right to know. The mother does not know the identity of the donor, and neither does her husband if she's married.
This is being considered by Parliament at the moment, though, under the Family Law Reform Bill. What is likely to come out of that?
Well, in the Family Law Reform Bill, the proposal is that children who are the product of artificial insemination by donor where the mother is married will be treated for all intents and purposes as though they are the child of their married parents, i.e. the social father is deemed to be the father of the child, even though he wasn't actually the donor of the sperm.
Now, if it was going to be made available for children to find out who their AID father was, could this open up fathers to claims for maintenance?
Indeed it could. It could open up under the new provisions contained in the Family Law Reform Bill an opportunity to apply for maintenance against the fathers of the children, and also for them to apply for custody and access to the child. So it would work both ways.
Let's now turn to some of the other rights that children have. Just run through a couple of those for us, first of all.
Well, one can say they have a right to be looked after properly, in the sense that there's a duty not to neglect them, there's a duty not to impair their proper development. Any situation where they might be left in precarious conditions, where they might injure themselves, can leave parents open to prosecution.
Right, so if we take, first of all, the case of parents having the child stay at home while they go out, is there a provision, a law against them leaving the child at home alone?
No law at all against them leaving a child at home alone. There's no age restriction either, so you could leave a child as young as 12 months, 6 months alone in the house.
What about with other people?
Again, there's no restriction on whom you can leave the child with. Of course, if you do leave a child on its own or with a person who might be considered to be unworthy in some way, then that could leave the parents open to proceedings in the courts, either through care proceedings or through a criminal prosecution under the Children and Young Persons Act 1933.
There's some control over childminders, though.
There is. There's the Nurseries and Childminders Regulation Act of 1948, which provides for registration of childminders and for them to satisfy certain conditions in relation to premises, care that's been taken, qualifications of staff, etc.
So there is a right for children to be cared for properly and not to be abused, and there are various welfare advisors to keep an eye on children from birth. To start with, health visitors have a statutory duty to make calls on all mothers with newborn babies. Margaret Nee, like all health visitors, is employed by the National Health Service. She's a qualified nurse and midwife who's taken an extra year's course in health visiting. Margaret is primarily a health advisor, but she's obviously on the lookout for children who are not being cared for properly. In one case, a nursery school teacher called her in.
She was worried that a child had been seen with quite severe scratch marks on its back. This was a case where a family from an ethnic minority group were using discipline because they felt this was right, and discipline which was really too harsh and unacceptable to our standards.
What were they doing?
They were using some form of cane, and the child had received quite a severe beating. So the parents were invited to come along to the school, and one of our school medical officers saw the child, spoke very strongly to the parents because she felt that the injuries were not consistent with just discipline, that they were too harsh. We then referred that family to the local social work team, who have arranged for a social worker, again jointly with me, to support that family, to try and talk them through the discipline question.
Health visitors themselves have no powers to force parents to change their ways, but they can refer cases, as we heard there, to social workers who do have those powers. When is discipline abuse there, Christina?
When it goes beyond what is reasonable. In the Children and Young Persons Act 1933, it is provided that it's a criminal offence to use discipline which is more than reasonable.
Right, and what about the right not to be abused? How can that be enforced in practice?
In practice, it may give rise to the institution of proceedings in the courts. Normally, this is preceded by what we call a case conference, where the interested professionals involved with children will be gathered together to discuss the best approach to a particular problem.
Is it just social workers who happen along these cases, though, who can do something about it?
Very often it's not social workers who will come to the cases first. The frontline workers in this situation are very often the health visitor where the child is under 5, or the school teacher where the child is over 5 or at school.
Michael, who we heard from earlier, is an all too common example of abuse at home. Social workers took him into care.
And my stepdad was the reason I've had to leave my home in the first place. Because he used to have a go at me when he came home drunk. Start hitting me. I've got 2 brothers and 4 sisters. They're all younger than me. They're all at home at the moment. Because like they ain't my real brothers, they're just my step brothers and sisters. And they're all his and I'm not. And I'm winning care before they even come around.
Sad case. Can children themselves complain if they're being abused?
They can complain. Probably again the frontline worker will be the teacher to whom they could make a complaint or suggest that something is happening to them which shouldn't be happening.
That's the difficulty, though, isn't it, for them to actually complain to somebody?
To come out into the open and actually make a complaint and realise what the consequences may be. They may be very fearful of being taken into care. They may have a certain amount of understanding of what happens. Folklore amongst children in the playground is such that they will understand the possible consequences of being taken into care, taken away from their families.
And will they be believed when they're complaining about someone?
I think the emphasis these days has swung very much into believing what the child says first and then deciding whether or not the child is telling the truth after you've conducted an investigation.
It can put children in a terrible predicament, though. Mary, for example, was physically abused by her father. Social services stepped in and applied to the magistrates' court to take her into care and out of harm's way.
Both my parents actually were sitting in the court watching me and, getting these evil looks from my dad. It's like totally frightening, thinking at the back of your mind, oh my God, what if I do go home and I'm standing up here, not knowing exactly where I stand. See what I mean? You don't know, oh, I could go into a children's home, but then again, at the back of your mind, you're thinking, I might go home, and that man will kill me for standing up in front of him, and he was giving me such evil looks. It was really, really frightening.
Of course, that situation does point up a problem which Parliament is considering at the moment in the Criminal Justice Bill, and that's the issue of giving evidence in court against the person who supposedly has perpetrated the crime against you. That is a very, very difficult situation. Not much really can be done about that in the sense that the person has got to hear the evidence against him, though there is a discretion in the magistrates to decide that provided the parents are represented and the parent's legal representative is in court, the magistrates could decide to hear the evidence in the absence of the parents, but that's almost never done in my experience.
In these cases of abuse, does the child get legal representation?
This is another vexed problem. The Act, the 1969 Children and Young Persons Act, does now provide for separate legal representation, but the discretion is in the magistrates to decide whether there is or may be a conflict of interest between the child and the parent. So it is very much discretionary, provided they then decide that the legal representation is necessary. Then they can then go on to consider whether there should be an additional appointment, that of a guardian ad litem for the child.
Is the child's view heard? They might have legal representation, but do they actually get to have a say?
The argument is that they should now do so, provided separate legal representation has been provided and that the guardian ad litem has been appointed. There is some view that, in fact, simply providing for a guardian ad litem who has to put forward the child's best interests to the court, that necessarily doesn't coincide with what the child thinks is in his best interest. If there is such a discrepancy of view, though, the child can give, provided he or she is old enough to do so, instructions to its solicitor to say, look, I don't agree with the guardian ad litem. I want you to say I don't want to go in care, if that's the proposal that's being put forward to the court.
If they are taken into care, again, they seem to have very little control over what actually does happen to them. Mary was being abused at home, but had no say about what the council did with her.
I was put in this children's home, which was absolutely disgusting. From being with such a large family, and then being put into this home where there was nobody there that was like a substitute at all. You were totally on your own, and so you felt guilty. You felt you were wrong. You didn't know why you were being punished for being physically abused. Why were you being punished on your own in this children's home?
Most of the other children in that home were there because their parents couldn't cope with them. They were very unlike her. Many had committed crimes, some took drugs, others even went in for prostitution.
And they all got 450
you get a lot of freedom in the care system. In the wrong areas, you get a lot of freedom as in bored in their spare time. But you don't get freedom as in making choices about your life. So in their spare time, they were so bored and didn't know what to do. And they've got this attitude of, well, nobody cares about me. So if nobody cares about me, what does it matter if I go out prostituting? It doesn't matter. Nobody's reassured.
Children, they were all got compensation.
Too much freedom, but not enough say about the important decisions made in their lives. believes, even though Michael is now happy in his home, he'd still like a greater say for children in care.
They should be asked what they want. And if they're not asked what they want, they'll just do things that they're not supposed to do. Like get it out of them a different way.
And more alcohol in
'Cause I've done it
teenagers
before, right?
in the care system proportionately
If
than
I
there is in the
can't
bloody
carry out the
UK.
things I want to say, I've either gone out and done something or I've just messed about. I'll just go out and mess about, like.
You're allowed to,
Say,
mate.
like,
No
I've
one
been
gives
trying
a
to say
shit about
something, but
you.
no one listen.
Well, you've pointed out that the courts are gradually listening more to what children have to say. What about the local authorities? That should they be listening more to what children want in the way of care?
There is a statutory obligation on them to give first consideration to the need to safeguard and promote a child's welfare throughout his childhood, and also to ascertain his wishes and feelings in respect of any decision. But I think, sadly, some local authorities do not listen to what children have to say and do not give as much consideration as they should be doing.
Should there be a children's charter, do you think, if we rounded up all the rights that we've been talking about in the last 25 minutes and encapsulate that, write that down so the children know where they stand?
That they should have a right to have their best interests considered and to have some say in what they believe those best interests to be. Though clearly at the end of the day, since they are children, someone else is actually going to have to take a decision as to what is in their best interests. And that would apply to the whole spectrum of rights or interests that we've been considering this morning.
And what about enabling them to be able to enforce those rights, make sure that something is done for them? Could we do more for children to give them that sort of power?
There is an argument which would say we could do far more, and that recent proposals with regard to legislation actually cut back the opportunities to enforce children's rights or interests, or to make sure that they are properly protected. But certainly I think we could and should be doing much more to guarantee them a say in the future.
What you've heard this morning may well have raised questions in your mind. Why not raise them in our follow-up phone-in this evening at 8:15 as well? We'd especially like to hear from you if you're a young person wanting help and advice. The telephone lines are open now for half an hour, and then they'll open again at 7 p.m. this evening. Your questions will be answered by Professor Christina Lyons, who's been explaining the law in this programme, by Peter Riches, social worker from the National Children's Bureau, and Mary Morgan from the National Association of Young People in Care, who you heard from just a few moments ago. You can call now in confidence and without leaving your name. If you prefer, the telephone number is 01 580 4411. If you'd like our fact sheet for the series, that will be ready in 2 weeks' time. It's yours for a stamped and self-addressed envelope. We'll be back at 8:50.
That number again, 01 580 4411. Family First to Last was presented by John Howard, researched by Alison Vernon Smith, and produced by Hazel Castells and Lynn Hartman.
Remember Hazel
And the address
Castells?
to write to for a fact sheet is Family Facts, room 726, BBC, Broadcasting House, London W1A 4WW.
Vernon Smith. Remember her name.
Now, just ahead of a lexicon of laughter,
John Howard with the second You and Yours phone-in in the series Family First to Last.
Hello, this evening we're answering your questions on children's rights. Does a child conceived through artificial insemination by donor have the right to know who that donor was? But at present they don't. If they did, could they also claim maintenance? How do adopted children track down their natural parents? Spare the rod and spoil the child is folk wisdom, but when can 6 of the best become child abuse? What amounts to neglect? And when will local council social services step in to take a child away from unsatisfactory parents? That's what we're talking about tonight. With me to answer your calls, Christina Lyons, Professor of Law at Keele University, Peter Riches, social worker with the National Children's Bureau, and Mary Morgan, who, since coming out of local authority care herself, has joined the National Association of Young People in Care as an advisor. If you'd like to call, the number is 01 580 4411, and we won't use your name if you want to remain anonymous. A lot of people have called already. We'll come to the first in a moment. But Mary, just explain what the National Association of Young People in Care sets out to do. What are you trying to do?
Well, they fight for the rights of young people in care in situations when they need somebody to talk to, and instead of using a social worker, they use NAYPIC. They phone in. Can be advice from a development worker there. It's also like a trade union for young people in care.
A lot of rights people in care have, we discovered this morning, but quite often they're not able to exercise those rights. If you're in that position, well, give us a call. The telephone number 01 580 4411. That's what Mrs. Pauline Parkinson did. She's calling from London. Let's hear what you've got to say.
Hello?
Hello.
Can you hear me? Yes, my point is it's Miss Parkinson. I work with 2 young children, but I don't have the children in my home. I go to their home. And because of that, I am not bound to be registered. In fact, I cannot get registered. And what is the... I mean, there's still the point that the child can be abused in her own home by a childminder just as much as the child being abused if you bring them to your home. I don't see the difference myself.
Right, well, Christina Lyon, that is the law, is it? If you have a childminder in your own home, there's no restrictions, no regulations covering that situation.
That is indeed the law, yes. I suppose it goes some way towards the English law principle of an Englishman's home is his castle. Basically, we don't allow the local authority to have control over what happens in the home until something goes wrong. Obviously, when there is a situation of abuse, then the local authority or the NSPCC could be called upon to investigate any allegations of abuse.
Someone like Peter Richards, the social worker, might be called upon, Peter, to look into a case like that?
Yes, it would be very difficult initially because of the position of the law. It would be necessary, I think, to go to the parents, of course, and to make sure that they were exercising their responsibilities in the first instance. And I think it's important to make it clear that although the law doesn't say that people visiting and looking after children in your own home have to be registered, that doesn't lessen the parents' responsibilities to check people out properly for their own peace of mind.
Pauline, can I ask you if you know other people who are doing this, being childminders in other people's homes, and whether you've got doubts about the way that they're doing that job?
Well, I have seen when I've been working very young people, very young girls who are looking after children while their parents are out all day. One, I don't see her now, but when I first met her, she was looking after a child, and then somehow or other she picked up another 2 children, and in one small buggy, she was taking one child that was dragging after her and putting the other 2 in this very small buggy. It seemed a very odd thing that people can get away with this kind of thing.
Well, as you pointed out, and as Christina Lyon has endorsed, that's the case, that's the law at the moment.
All right.
Perhaps it's not satisfactory, but there we are. Thank you for making that point, Pauline. Thank you for your call. Let's go to Kent now. Mrs. Stevenson, would you tell us what you've got to say, please?
Well, my case is quite different. I just wanted to ask you, the social worker, what they can do. Well, it seems that they have their hands quite tied up with the law, because I have a case for child abuse, and they were very, very helpful, but then the judge, we went to court, and the judge really was very unsympathetic and very unrealistic, and now the social services can't do anything at all.
This was your daughter, was it?
Yes.
And
they can't do anything until something happens again.
Who was abusing your daughter, you're saying?
Her father, my husband.
Right, and the judge has allowed the father access to the children still?
Yes, complete free access and supervised.
And you simply want to know if there's anything you can do about that?
Anything they can do, because it seems that nobody can do anything until something happens again.
All right, well, let's get the comment of our experts here. Peter Richards, first of all.
Well, I presume, Mrs. Stevenson, that the father of the child was not actually taken before a criminal court for any child abuse. Is that right?
No, it wasn't.
Yeah. So there was no actual proof. Yes, I understand. That does make it very difficult, as I'm afraid you found out, because if the judge doesn't believe you, and I assume this was a wardship hearing in a high court, that those judges do have a great deal of power. And if they have said that the access doesn't have to be supervised, then they can't compel the father to only visit when there is a social worker supervising. However, it might be worth your talking to the social workers again to see if they might be prepared to assist and be around when he does visit the child to see if it's possible to reach some agreement by negotiation. But as far as I understand it, and Christina may be able to help here, there is nothing that you can probably do in law at this stage, I'm afraid.
Professor Lyon, whether that's the case, then.
Yes, I think that's probably right. If you've had the wardship hearing and the judge has decided that he basically believed husband in this case, the father of the child, then that decision has now been made. And even if you were to consider an appeal to the Court of Appeal, it's very unlikely, given the current law, that they would interfere with the first instance judge's decision in this case. So, unfortunately, at the moment, as the law currently stands, things are somewhat problematic. It is fair to say that under the Government White Paper, the Law Commission's White Paper, on provision of family care and child law services, that there would be a change where there would be a fear of likely harm to the child, and this case might then come within the new proposals, but that isn't law at the moment.
That's the situation, Mr. Stevenson. Thank you for your call. We had a lot of people calling. Some would rather not go on the air, and this is an example of that. Let me read out this particular case. A lady telephoned a little while ago. Her daughter, aged 32, is an alcoholic and has a 7.5-year-old boy, and she may lose her job and will drag the child with her, says the caller. If he's picked up by social services, will he have to go into care, or could the family be allowed to claim care over him? She's divorced, the daughter, this is, and has custody of the child. The father would take him, but the daughter refuses him access, and he's not pressing his rights. He does pay maintenance, though. There is also another daughter who might have him. It's a great worry to this particular caller, but can other members of the family, in circumstances like that, ask for care of a child rather than see it going into council care?
Certainly under the provisions of the Child Care Act 1980, if voluntary care is being considered rather than taking care proceedings in respect of the child under the 1969 Act, then yes, it is in fact the obligation of the local authority to discover whether any other relative of the child would be prepared to take on the child. Then, of course, the local authority investigate whether that person is the appropriate person to take on that care. But indeed, there should be an investigation, and it should be possible for them to take on the care.
Mary, was that a possibility in your case? And other people that are in care, do they have that option put to them that they might go to other relatives? In your experience?
Not in my experience. It wasn't, but some people, I think, can go to other members of their family. It's possible anyway.
And is it then a good idea for children who think that they might be taken into care to try and make arrangements within the family?
I think that'd be a very good idea. I think it should be looked into more, actually, rather than, think, oh yeah, let's take them into care and that's it. Look at other members of the family and see if they're suitable.
Children in care, do they really see it as the last resort to go into a foster home or into a children's home?
Yeah, I would say care would be the last resort.
So any other opportunity would be worth them trying to seek out. Peter, what is the attitude of local authorities? Do they canvass that as much as Christina Lyons suggests? Perhaps they ought to.
Well, it does vary enormously, of course, but I think on the whole that if a family went to the Social Services Department, their first port of call would be to look at the most obvious groups of people that might look after the child, for example, the husband. I think what worries me is that in too many cases they wouldn't necessarily then go on to look at other members of the family who may be able to look after the child quite adequately and in fact quite positively in such a way indeed that she may well be returned to the mother eventually.
What about this particular grandmother, as it is here, wanting to look after this 7.5-year-old boy as an alternative to the local authority? What should she do?
Approach the local authority and indicate to them that she would be willing to look after the boy.
Pop into social services, ring them up?
Yes, make sure that they are aware of her existence and that she's willing to have him and able to look after him. They may even consider approving her as a foster parent. I do know some authorities, certainly in the northwest, that are prepared to do that.
Right. Good. Well, some constructive advice for that particular lady who rang a little earlier. The telephone number, if you'd like to ask a question, is 01580 4411. Mary did that. She's calling from Coventry. Can we have your question, please?
Hello.
Hello.
Hello. I'm phoning about my what I call my stepson. It's my husband's son, and his ex-wife has custody. At the moment, he's 14. But apparently, when he was younger, he suffered quite a bit of abuse from his mother's husband. When he was 6, we took him on holiday with us, as we usually do anyway. His mother and his lover went away on holiday themselves, and they came back married. No, he didn't know, nor we didn't know either that they were going to get married. But consequently, when he was 7 or 8, things didn't seem to go quite right, and we heard this only from him from a few years ago when he was about 12, 13. The father, well, not a stepfather, but this mother's husband, used to beat him with a belt and humiliate him in front of the family. And now he's 12, 13, he's very bitter and very, very angry about it. And we said at the time, why didn't you tell us, for goodness sake, why didn't you tell us what was going on? But obviously he was too scared at the time. And so was his mother, I presume. And nothing was said. But now it's quite, it's quite old, he's 14 and quite tall as well. I wonder if he could do anything for himself, because he must feel he was left in a trap and he couldn't do anything about it.
Yeah, this was 6 years ago.
Yeah, but from being, yeah.
So really, you want to know what can be done to make sure that he doesn't do anything silly.
Yes.
And also whether there's anything that can be done against the person that committed those offences in the first place.
That's right. The person who committed the offences, they've now split, so he's not living with him anymore.
All right. Let's find out what Professor Lyons would suggest in those circumstances.
I think the most important thing for this boy to do now he's started talking is to keep talking, but I'll let Peter and Mary perhaps deal with that particular side of things. In relation to possible criminal proceedings, the situation now, the mood of the country now is very much, of course, to believe the child. It's possible that you could approach social services and ask them for some assistance with this, and they might consider that it ought to be referred on to the police. Would you, in fact, like to countenance the boy taking criminal proceedings or trying to institute criminal proceedings now?
Well, I'm not quite sure. It could be possible, though. He does feel so very bitter, and he feels this way all the time, and consequently, I think he suffers at school through as well, lack of confidence, and can't concentrate and things like that.
Yes. Who has he talked to, in fact, about this? Just you and your husband?
Yes, mainly to us, more often to me. It comes down to bits and bobs, and when you think about it and build it up, it sounds quite nasty.
Is it possible for the police to do anything about it so long after the event?
It would certainly be difficult, and it would be a case of his word against the father's, the memory, the precise sequence of events and all this sort of thing. It would be extremely difficult. I think this is more a case of it's good that he's now started talking, and he really should be directed to somebody who can really be of assistance to him.
So the possibilities there of going to the police and discussing it with them, but let's talk now about what can be done for this particular young chap, Peter Richards.
I think that, as Christina so rightly says, that he should find someone to talk to, and hopefully he is now talking to his mother a bit more, and I'm sure he will find that helpful. It could be a whole range of people. It depends who he finds is the adult that he feels he can trust most. There must be someone around there somewhere. There may be someone at school. There may be a particular teacher that he can talk to. If he goes to a youth club, he may find a youth leader. If he finds that there isn't anybody immediately available, there are youth advisory services around in a number of parts of the country where you could get particular advice. Or failing that, there are particular services like the social services, for example, and child guidance social workers. But my guess is that he might find that quite difficult, at least initially, and he probably needs to talk to someone really just to gain some confidence and to see adults as reasonable human beings rather than people who just knock you about.
Let's find out from Mary if she can suggest the sort of people that would be most suitable to do that, to discuss it with him. What would you suggest?
Well, like you said, if he has a good friend or teacher or whatever. Also, he could have counselling. A lot of children in care go through all this and then they have counselling. But what you said about bringing it to the police, that just sounds like a really bad idea. It would put him through a lot of hassle. It would bring back a lot of memories, and it's not really a good idea. I think the best thing for this boy would probably be to have counselling and have it quite soon if he's going to have this sort of personal vendetta against this, what is it, stepfather or something? Yeah? And he would probably...
But it's who, isn't it? Who's going to do that counselling? It's finding
Well, I don't know. I mean, maybe...
I think you would know. Yes, well, it certainly could do. I think the important thing is that your son actually finds someone that he can trust.
Yeah, I was about to say that because, I mean, you suggest the counsellor and the boy would probably tell them to,
Child psychologist, it's a good idea.
It's a good idea. I think the important thing, though, is that you ask him and that you get his confidence in whoever you approach.
How do you get through to a child psychologist? Is that through the GP or family doctor?
Yes, again, or if there happens to be something called a child guidance clinic or a family and child psychiatric service. Unfortunately, they've got different names in different parts of the country. Or if you just ring up the social services department, they will be able to tell you where.
Right. I suppose there must be a lot of cases like this, and children actually have personal vendettas against one person out to get them for a long time. So I think it's good to broadcast something that a child, and the telephone number a child can actually contact and do something about it now.
Yeah. And who would that be then? Who would we suggest?
I wouldn't know, would you? Youth advisory person.
Yes, I think unfortunately the tragedy is that the services are so varied over the country for this sort of problem. But I mean, I think the important thing is to go to someone, whoever you think perhaps as the mother is trustworthy in the first instance. Although you may find that your son actually does know someone that he can go to, and then you can take it on from there.
Okay, Mary.
Yes, I just want to put one point. The person who was doing this mathematics was actually a school teacher, and he did teaching in a class at a school, and this came out in the school as well. He's picking on in that school. So teachers, I think, are out because of that.
Yeah, that doesn't sound a good idea. Yeah.
Well, perhaps your own idea of the child psychologist is as good as any that we've managed to come up with, and that's worth trying through your GP, getting in touch that way. Thank you for your call. I must apologise for the hum, which we've got on our phones. It's not your phones. There's a little hum there, and I hope it's not interrupting your being able to hear what people are saying. Let's move now to Cambridge, where Mrs. Smith is calling us. Tell me what you'd like to say, Mrs. Smith.
Good evening. I have a 14-year-old daughter who has a school friend who has a growth problem. She's very small. It was picked up by the school routine medical health, and she was sent to the local hospital with her mother. There they said that yes, there was treatment she could have, and her mother refused her the treatment. Now, as far as I'm aware, there is no religious reason for this. She just felt she didn't want the child to have this therapy, which will make her grow.
How old? Just give us the age again. 14.
The child herself would like to grow.
Right.
And doesn't know what she can do. Has she any rights?
Clear case of medical choice for someone who's under the age of consent and still under the control of the parents, effectively. Let's find out what Christina Lyons has to say.
Well, of course, following the case in Gillick, in the House of Lords at the end of 1985, it is now possible for doctors to take the consent of a person under the age of 16 to a course of treatment, provided the doctor forms the view that the child is of sufficient age and maturity and understanding to appreciate all the consequences of the treatment that's being engaged in. Of course, the Gillick case concerned contraceptive advice and treatment. This concerns something relating to growth. And I would say that the girl should make it known to the doctor that she has this view, that she does want to have the treatment given to her. Then, of course, it's up to the doctor then to make the decision as to whether he feels that she's of sufficient age and maturity to appreciate all the consequences. But following Gillick, that option is certainly open.
Right. The problem is, of course, that it's not her GP who would give...
No, it's the trans, but you know, there was nothing to equate it. It was only the trans thing, which was abusive.
As we were hearing earlier in the day, that although children have rights, it's often very difficult for them to enforce those rights when the parents don't wish them to.
That's right. They have to carry on living with the parents and the consequences of doing that.
Let's see if there's a suggestion we can make there.
Well, again, possibly an approach to social services to see if they could help to persuade the parents that this is really treatment in the girl's best interests. Is there any reason why the mother is objecting?
Not that I'm aware of.
So no conscious religious or other grounds, no. Well, in that case, then I think an approach to social services may be worthwhile. Of course, the problem with that in the eyes of the girl may be that that may call down all sorts of consequences of involving social workers and possibilities of care proceedings, because you could argue that this would be, I don't know what Peter thinks about this, but this would be something which would go towards the child's proper development.
Peter Riches is a social worker. What would you suggest here? How would you combat that?
Well, I think it could get to that stage, but I think it is a little like the situation we were discussing before. I mean, what I think the girl needs in this situation is a friendly adult who's prepared to help her through the system, to negotiate and help with the GP so that the girl can have private appointments that aren't necessarily known to the parents, at least until a decision is made. But also it is important to, if the situation is obviously known to the parents already, so there's no way that things can be done entirely behind their back anyway. And a responsible adult, and it may be that the social services with an air of authority about them are the best people in this situation to actually help to negotiate and persuade the parents, which would easily be the best result in the long run.
Yes. You see, I had considered getting in touch with her GP and seeing if he would have a word with the parents, and seeing if he could persuade her the medical advantages of having this done.
So are you suggesting that he hasn't done that? Because
I don't know whether the GP has or not. All I know is that this was referred to the hospital, and at the hospital the mother refused the treatment.
That's certainly a first stage, isn't it? But if that doesn't work, the doctor cannot take further steps. But am I right in saying that if the social workers went in and had a word with the parents, and that didn't work, the social workers could actually take more direct steps for the child?
Yes, they could do. I think what's slightly worrying me about this is that one wouldn't want the girl to fear going to the social workers because she thinks she might end up in care. I think that she should be assured that the social workers would actually try to negotiate first, and only if things got to a very extreme stage where there was complete lack of cooperation would they need to consider legal action.
Right.
Okay.
Fine, thank you very much.
Thank you for calling us. And it's Susan Bernard, I think that is, from Cheshire, who's calling us now.
Good evening.
Good evening.
My question concerns legal obligations as a parent, a matter which you touched on in the programme this afternoon. I get the impression that the law on this matter does seem to be very poorly defined. I must say I was very surprised to learn during your programme that there is no actual minimum age for leaving a child alone, for example. My own knowledge of this subject is very fragmentary. It consists almost entirely of information I've gleaned from friends who say to me, oh, by the way, did you know that you're not supposed to do such and such? And my answer is nearly always, no, I didn't know. For example, I was told that I'm not supposed to leave a child under 7 in a room with an unguarded fire. What I was wondering is, are there any means of making a parent's obligations better known? It would be very distressing to a parent in the event of an accident to discover that they'd also unwittingly been guilty of negligence.
Are many of these things, though, leaving children in rooms with fires, are they not common sense?
Yes, but for example, something like that, for instance, where there is a legal, or there may be a legal obligation which is not necessarily known. And what I was wondering was, I know your programme has gone some way towards remedying this grey area, this ignorance on the part of parents. But would it be possible for perhaps health visitors to be told to brief new parents on such matters?
Well, it's a good thought. Let's find out, first of all, from Christina Lyons about the particular obligations that you've been talking about there. Just run through a few of them for us, Christina, and why they aren't more widely known.
I think the point about dissemination of information is a good one. They should be more widely known. There is a booklet published by the Children's Legal Centre which gives age limits in relation to this sort of thing. Certainly you're right in relation to leaving a child in a room with an unguarded heating appliance or fire. The age limit is in fact 12 and not 7. Right. And there's also a provision again in the 1933 Children and Young Persons Act which says that it's a criminal offence to give a child under 5 alcohol. So again, that could cause a few problems, I think, to some people, just occasionally. Those are the principal sorts of age limits that are laid down in the 33 Act, and the remainder of the position is much as we indicated in the programme at lunchtime, that in fact, generally speaking, in relation to positive duties, the law is couched in, if you like, rather negative terms. It's a duty to ensure that you do not inflict unreasonable punishment on the child, that you take steps to see that the child is not neglected or abused or ill-treated, or that their development is not impaired.
So it's more a chance of that or not than yourself.
It is indeed, yes. But I think your point is well made, that there ought to be leaflets available in antenatal clinics and, of course, in the child clinics that you have to take the children to after they're born.
You did mention a booklet. How would one get hold of a copy of that?
By writing to the Children's Legal Centre, I should imagine, and again, I would think the address will be on the fact sheet.
Yes, we can give you to that address right now. Actually, Peter Richards, I think, has got it off the top of his head.
It's 20 20 Compton Terrace, which is London N1. Perhaps I could also mention that I know that the Consumers Association also publish a book on children's rights and parents' rights, which includes a lot of the information from that leaflet.
Right. Thank you, Mrs. Barnard, for your call. Can I, Christina, put you to something that has been put by a number of people, and that is when we said this morning that discipline must be reasonable. What is reasonable, people wanted to know. It's very unclear, really. It seems to leave things very much up in the air.
Yes, it's not defined in the statute as such, so it's going to be left to individual circumstances for people to decide what is reasonable or unreasonable. Anything which goes beyond the bounds in the particular situation of lawyers fall back again of what is reasonable. It really isn't capable of precise definition. But it is obviously unreasonable, for example, I would imagine everybody would probably agree with this, to seriously hit a child with a cane, the case we were referring to at lunchtime, discovered by the nursery teacher. A child under 5, you would not countenance hitting with an instrument. That would clearly be unreasonable.
A call here from Carol from Guildford. I'll just read this one out. She's severely disabled, her husband has died, and has a 19-year-old son who lives with her. He has threatened her life and used violence towards her. How does someone in that situation cope? It's the other way round. Here we have a young person who is threatening violence towards an older relative. What rights does the older relative have in those circumstances?
Well, they have to fall back again on what we call common law cases. There is a power within the county court to issue injunctions, provided you can prove some damage. What you do is to allege a tort of some description. That's a civil wrong of assault or of trespass to the property or of damage to the property, and then you link to that an application which we call ancillary to the main issue of damages, although in reality the issue of damages or assault is a minor matter.
Well, you're saying then that she can take legal steps, but yes. This young man is living with her. It's going to be very difficult again for her to try and do something about it when he's living with her.
That's right. I mean, it's a very problematic situation and one which causes a lot of heartache in this sort of set of circumstances. It's
Peter Richards, is there a role for social services in this case?
I think very much so. I mean, not that I'm suggesting that it's easy to solve that sort of difficulty, but I guess, and I don't have many of the facts obviously, but I guess that in fact the son is also feeling fairly frustrated with the situation that he's in. Not that excuses the behaviour, but it may be that if additional helps can be put into the family to look after the mother, that he may feel less frustrated. It may, in fact, be quite able to cope quite amicably. That sounds rather easy, and it certainly isn't. But I would advise the mother to talk to any of the professionals who are coming into the home, the district nurse or the social worker or whoever it might be, to see if there is a way of actually providing some additional support.
Right. We'll move to some questions about adoption now, another issue raised this morning. Patricia Till, calling from Winchester. Let's hear now from you.
Some weeks ago, I rang up the hospital where my mother is, and I asked how she was, and they said that she wasn't there anymore. So I asked them where she was, and they wouldn't tell me. They said that I'd have to ring through to the medical office, which I did. And they said that I would have to write in. So my friend wrote in for me, and I got a letter back saying that they look into it. Now, why does one have to write in? That's what I want to know. I haven't done anything wrong.
You were adopted?
I had foster parents.
Right, okay. And so you're wanting now to trace where your mother has gone to?
Yes, and they wouldn't tell me. They said that I asked through to the medical office, record office, and they said that I have to write in. My friend wrote in for me. I got a letter back, and all they said was they'd look into it. That's all.
Okay, let's see if we can analyse what's happened here. Christina, can you work out what's happened here and why the requirement to write in to find details of her mother, a natural mother?
In this particular case, it sounds very strange because the woman has not been adopted and therefore obviously has known who her natural mother is. I can't really see why there are being steps taken to prevent contact unless the mother is very mentally disturbed or distressed, and perhaps there have been grounds for saying that contact with the daughter is causing additional distress.
Peter, what would you suggest here?
I wonder whether there's been any contact with the hospital social workers here. Has there been?
Patricia, have you been in touch with the social workers at the hospital?
No, all I was told to write in, and they said that they would look into it. That's all I had back. When I got a letter back the other day, they said they'd look into it, and they didn't. That's all they put.
Right.
Well, perhaps I could advise you. I mean, it does vary depending on which hospital it is and whether it's a small hospital or whether it's a fairly large one. But there will be a hospital social worker attached to the hospital in some way. It may be that they just do a few sessions a week. You can find out either by just phoning up the switchboard of the hospital or asking for the hospital social worker. If they don't know, then you can get through the local social services department who it is. And once you make contact with them, they should be able to help you through the system. It may be that you've just been greeted by someone who's dealing with things in a very bureaucratic manner and isn't realising the personal circumstances involved.
Well, I gave them all the details I could, as far back as I could. You know, right where I was born and everything. I gave them all the details, what needs to be known.
Well, I obviously can't speak for them, but as I say, I think certainly if you're looking for your real parents, then the people who would need to actually find those facts out and counsel you about it would be the social workers anyway, rather than the medical records people who aren't, let's be honest, trained in human relationships, and therefore it would be better to go through the hospital social worker, and it's also the right place. So you may find a bit better luck there. I hope so.
Right, that's the direction to go in then, Patricia. Richard called us. He's an adopted child. He knows he was born in Woking, he says. How can he find out who his mother was? Where does he start? This is a common question, by the way. Can you just run through the details for us, Christina, of how you go about tracing your natural parents?
Well, provided you're over 18, because of course in England and Wales that's the age at which you're allowed to approach the Registrar General and make an application to his office for disclosure of your birth records, and the Registrar General is then obliged, if you were adopted before the 26th of November 1976, to say that you must go through obligatory counselling. If you've been adopted since then obviously, you may not actually be 18 as yet and therefore unable to pursue this particular line. But once you are 18, then you can make an application and you will undergo counselling if you were adopted before November 76 and be told basic details.
And what are those? Name and past address, things like that?
That's right, yes, as much detail as the agency has on its records.
So Richard gets in touch with the Registrar General, gives his details, they will have details of his natural parents and last addresses that were registered at least.
That's right.
So that's how he does it. He also says, can we broadcast details of NORCAT? This is the National Organisation for Counselling Adoptees and their Parents. I'll give you the address of that in just a moment if you would like it, but let's deal with this one along similar lines first of all. Mrs. Heal from Weston-super-Mare. One of 3 children born to an unmarried mother, she wants to trace her 2 natural brothers. Can anyone tell her how she can go about that? Not easy?
Not easy, no, because the provisions of the Children Act actually talk about tracing parents and not about tracing brothers and sisters. The first step is to trace the mother and hope that she'll have the relevant information, and also to approach the adoption agency which placed the children to see if they would be prepared to release information.
So she's got to track down the adoption agency who will have a file of where her 2 brothers are now, or
were placed, I think is probably
right,
correct.
yes.
And there's no obligation, as I understand it, for the people to keep in touch with the agency. I mean, the agency drops out, don't they, Peter, after the...
Well, that's absolutely right. It may be many years ago, of course, and records kept a long time ago aren't necessarily in very good condition, so one wouldn't want to be too optimistic, but it's worth a try.
Okay, and again, NORCAT may well be able to have Mrs. Heal. Their address is 3 New High Street, Headington, Oxford. 3 New High Street, Headington, Oxford, OX35AJ. Again, that address in our fact sheet. We'll hear from Mr. Banks, calling from Llanelli now.
Good evening.
Good evening, dear.
My question really concerns fostering. My wife and I started fostering for our local authority last November. We had 2 sisters from the same family and who had previously had 4 or 5 foster homes where they were extremely unhappy. Now they've been very happy with us and settled down very quickly. And from the beginning we were encouraged to pass on information to the social worker concerned
You were saying, are you, that the children would like to come back to you?
That's right, and in fact they've written to us saying this is what they want to do.
Two situations here then, the children's rights to come back to you and your rights over the children as well. So two areas we want to look at.
And then, in fact, their mother as well would prefer that they came here than went to any other foster home.
Let's see what Professor Lyons can tell you about all that.
Unfortunately, foster parents occupy what we call a nil legal status in English law. They are literally nothing in relation to the children that they look after until such time as they might be in a position to apply for custodianship or perhaps adoption if they're going that far. You only have the children, it sounds like, for some 4 or 5 months. And the statutory schemes are such that the local authority almost have these days an unchallengeable discretion as to where they place the children. It would only be if you could prove maladministration or bad faith in the exercise of their duty to give the children's welfare first consideration that you would stand a chance of challenging the local authority's decision. And that would be done by a rather complex process called judicial review in the High Court. And I can't say that I would hold out much hope for that. There would at one time have been a possibility of using wardship, and it could be suggested that, again, you could try this. But I'm afraid I couldn't hold out very much hope in this sort of situation.
What about the children's rights then?
Unfortunately, again, they are in a very difficult position. They, of course, under the provisions of the Child Care Act, should have had their wishes and feelings taken into consideration. Clearly, they haven't been.
So can they do anything now?
No, in reality, I think their wishes and feelings have not been taken into consideration, but then the local authority is only directed to take these into account insofar as it is practicable. And clearly, the local authority, through the social worker here, has made a decision for whatever reason that indeed the children should now have been moved to another foster home.
Peter Riches, is there anything from an inside view as a social worker that Mr. Banks can do? It must often be the case that foster parents perhaps don't get on with an individual social worker. And is that just unfortunate, or is there anything else that can be done?
Well, there aren't as many things that they can do as I think there should be. And I think there's a growing movement to suggest that a number of people, both foster parents and indeed the children themselves, should have access to a formal complaints procedure, as well as to the law where that's appropriate. I think that Mr. Banks suggested that they had made some contacts with different people in the social services. I would suggest at the very least, if he hasn't already done so, that it would be worth writing formally to the Director of Social Services. If that's been tried and hasn't produced any results, the people who are legally responsible in the end for the social services are, of course, the council. And there will be a local councillor, as well as the chairman of the Social Services Committee, who could well be approached. Now, again, as I've said before, the situation varies a lot over the country, but in a lot of places that really can produce some effect, so it's well worth trying. But again, if there isn't an official complaints procedure, you really have to be quite clever and persistent to find your way through that system.
We've also got with us Mary Morgan from the National Association of Young People in Care. If the children that want to go to this foster home got in touch with you, what sort of advice would you give to them?
Well, we'd tell them exactly their rights. We'd phone up the Child Legal Centre. They'd tell us their rights.
Is there anything that you can see that they could do in their position?
I don't know. It depends on the individual case, obviously. The social worker must have some good reason why he's not bringing these children back to this. I mean, it seems like the foster parents want them, the children want to go there. There must be, a third point to the situation. But I think that the child should definitely have the right and should definitely know about people like NAYPIC, so they can actually phone up and find out their rights, because in a situation like this they feel they've no one to turn to because the social workers have actually said, no, you haven't got a choice. So
Great. Mr. Banks?
Yes, that's absolutely correct, actually. Our problem is that there doesn't seem to be any way of monitoring what social services do. They're constantly hiding behind this veil of secrecy and involving other people in their affairs. We have been through the Director of Social Services and through the Council. Of course, they're coming back with the same story, on which we're never, ever getting a full explanation on the problem.
I think in the last analysis, if you wanted to pursue the complaint, you could try your MP as a next resort, but also the local government ombudsman maybe a complaint to him to investigate the matter, since you would be able to establish that you've pursued all other complaint processes.
Okay, thanks very much indeed. I mean, what that case highlights is that individual social workers actually have a tremendous influence, don't they, over the outcome of what happens to any particular child. Penelope Stubbs, calling from Berkshire. Penelope, let's hear what you've got to say.
My point was that a child that is abused at home and complains to a teacher or to a friend, what happens to them is they get taken into care and removed often from their mother and brothers and sisters, and if the abuse has been from the father, why isn't the father maybe removed if they need treatment to do with alcoholism, or if they've been abused so they're doing it to their children? Why is there not some sort of protection for the child, because he gets punished twice, once at home and often removed?
Penelope, let me get the legal position on that very briefly from Christina Lyons, because we'll have to wrap up. Is it ever possible for the parent to be removed, the parent that's at fault?
It would certainly be possible under provisions. If the parents are married, you could use both the Domestic Proceedings Magistrates Courts Act to get a personal exclusion order as well as a personal protection order. Of course, it's difficult. It doesn't guarantee protection for the child, and that's what may concern social workers. And there are also provisions for violence, domestic violence injunctions, and again exclusion orders in the county court under the Domestic Violence Act of 1976, which also applies to couples who are living together as well. And I should stress that the protection in both cases extends to foster children who are living with the applicant. In relation to the 76 Act, that applies. In relation to the 78 provisions, the Magistrates Court, it has to be child and family.
Right. Well, thank you for tidying that up at the end. Thanks, then, to Professor Christina Lyons, Peter Riches from the National Children's Bureau, and Mary Morgan from the National Association of Young People in Care, and to you for your calls. If you'd like the fact sheet for the series, it'll be available in 2 weeks' time, but you can write now the address Family Facts, room 726, BBC, Broadcasting House, London, 184WW. That's it from me.
Well, I'll go. Probably.
Family First to Last was presented by John Howard.